But now there is a right to possess a handgun outside the home.
And every conservative in this Congress to stand with Representative Clyde and his legislation and to stand with me.
Which changes now we have an administration that is desperate to erode our Second Amendment rights.
The ATF before they abolish our Second Amendment rights. Alcohol, tobacco, and firearms.
And it's time to, once and for all, let those swamp creatures know.
Supreme Court ruling. All right, let's break down what's been shaking in the high courts lately. So the Supreme Court has dipped its toes into the raging debate over attack weapon bans, and boy, it's creating ripples in the firearm world. Picture this, the highest court in the land, the Supreme Court, has been throwing around judgments on attack weapon bans like confetti at a parade. It's the kind of drama that makes you sit up and take notice. They've been making moves that could redefine the whole ballgame of firearm regulations. So here's the lowdown on what's been going on. The Supreme Court has been flexing its legal muscles, scrutinizing attack weapon bans left and right. It's like they've grabbed a front row seat to the hottest show in town, and they're not afraid to voice their opinions. Now let's talk implications. This isn't just legal jargon being tossed around. It's about the very fabric of firearm regulations getting a shakeup. Millions of gun owners are on the edge of their seats, wondering if they're about to become unintentional felons. Why? Because the Supreme Court is essentially playing referee in the match between gun rights and state-imposed bans. Think about it. Your average Joe who owns what's deemed a common rifle or mag might suddenly find themselves in the crosshairs of the law. The Supreme Court's recent rulings are like a wild card in this poker game of rights and restrictions. But here's the kicker. The Supreme Court isn't playing ball like we'd expect. They're not swooping in with a clear stance or a one-size-fits-all ruling. Instead, they're tossing the hot potato back to the lower courts, leaving the fate of these bans hanging in the balance. It's a bit like watching a nail-biting cliffhanger at the end of your favorite TV show season. You're left wondering, what's next? The Supreme Court's decisions are opening the door for a flurry of legal battles in states like Illinois, where folks are fighting tooth and nail against these attack weapon bans. In a nutshell, the Supreme Court's recent involvement is like throwing a grenade into the already heated debate on firearm regulations.
And it has one magazine. So after 30 rounds, I'm done.
By now, instituting this 120-day rule.
Is this a common problem where our criminal justice system has a revolving door? Let's see what is the most compelling thing to learn from that case. How many times was this gentleman? Thank you, Ms. Swear. Let's revisit. Is it the Rahimi case? Is that the right name?
But now there is a right to possess a handgun outside the home.
Is that we are systematically failing to draw and enforce a line as to how much repeated criminal conduct we are willing to.
$1.9 billion to law-abiding citizens.
Our right to keep and bear arms shall not be infringed. I yield back.
It's not just about legal technicalities. It's about the very real impact on everyday gun owners. So as the legal showdown unfolds, we're left with more questions than answers, and the fate of attack weapon bans hangs in the balance, waiting for the next act in this legal drama. Illinois battles against ban. All right, folks, let's dive into the Illinois battleground, where gun owners and advocates are locking horns with the state's attack weapon ban. It's a legal showdown that's got the whole nation watching, so grab your popcorn and let's break it down. First off, picture Illinois as the epicenter of a legal storm. Gun owners are there gearing up for a fight of their lives against the state's attack weapon ban. It's not just a tussle over regulations, it's a clash of ideologies, with both sides digging in their heels. Now, updates from the front lines. Legal battles are raging like a wildfire. Advocacy groups are slugging it out in courtrooms, pushing back against what they see as an infringement on their Second Amendment rights. It's like a high-stakes poker game with the state playing its hand and gun owners refusing to fold. Challenges? Oh, there are plenty. Imagine waking up one day thinking you're a law-abiding gun owner only to find out that you might be on the wrong side of the law. The attack weapon ban in Illinois has thrown gun owners into a legal maze, leaving them scratching their heads about what's allowed and what's not. And it's not just about the legal jargon. Gun owners are facing the very real threat of becoming unintentional outlaws, all because they own what the state labels as attack weapons. These aren't just fancy firearms, they're everyday rifles and mags that millions of Americans legally own.
Not only has it been completely blown out of proportion,
that over a third of individuals convicted of violent felonies.
And every conservative in this Congress to stand with Representative Clyde and his legislation and to stand with me.
There's a hearing that you can't be at, your counsel can't be present, you haven't been charged with the crime.
And now the ATF, under the guidance of this administration, is coming to take away.
We're either out on probation, parole, or pretrial release at the time of those offenses.
My speech is well beyond the 2 minutes that I'm allotted, so I'm just going to dispense with the notes, really.
So basically it's saying if there hasn't been something like this done in all of our history, then it can't be imposed, right?
Under any administration would become an ally. It needs to go. We need to abolish.
Advocacy groups, on the other hand, are rallying the troops. They're not just fighting for the right to bear arms. They're fighting against what they see as government overreach. It's a classic David versus Goliath scenario, with gun owners and advocates taking on the might of the state. But here's the kicker. The legal tug-of-war isn't just happening in the courtroom. It's spilled out onto the streets and into the public discourse. It's become a hot-button issue, sparking debates in living rooms, coffee shops, and community halls across Illinois. As the battles unfold, gun owners and advocacy groups are facing a dilemma. Do they comply with what they believe are unconstitutional laws, or do they stand their ground, risking legal consequences? It's a tough call, and the stakes couldn't be higher. Millions face legal consequences. Hold on to your hats, folks, because we're diving into a situation that's got millions of Americans on edge: the potential legal consequences of the attack weapon ban. This isn't just some legal mumbo-jumbo, it's a real roller coaster ride that could turn law-abiding citizens into unintentional outlaws. So here's the lowdown. Millions of Americans wake up one day thinking they're just regular folks who happen to own what they believe are common rifles and mags. Little do they know, they might be walking a legal tightrope, and that's thanks to the attack weapon ban that's thrown a wrench into their firearm ownership. Now let's talk consequences. And we're not talking about a slap on the wrist. We're talking potential felony charges for Joe Schmo who just wanted to exercise his Second Amendment rights. It's like finding out your everyday run-of-the-mill firearm could land you in hot water with the law. These aren't James Bond-style gadgets we're talking about. We're talking about rifles and mags that millions of Americans have in their homes, thinking they're on the right side of the law. But thanks to the attack weapon ban, it's like someone changed the rules of the game overnight, and now these folks are facing the harsh reality of potential felony charges.
As a duly elected official and a gun owner myself,
at the firearm industry. That is all this is and nothing more.
One of the statistics I didn't get a chance to get to was that between 1990 and 2002, the Bureau of Justice Statistics reported
the impulsive leaders at ATF have once again failed to apply simple logic and reason to their decision-making.
Contrast that with what Republicans did to address gun violence and crime the last time they were in charge.
Two others, I'm not sure whether they were misdemeanors or felonies under Texas law.
Okay.
which changes now we have an administration that is desperate to erode our Second Amendment rights.
When it comes to people who are exhibiting violent behavior?
And believe me, this rule has nothing to do with gun safety. This has nothing to do with making communities safer.
It's a bit like a legal whiplash. You're minding your own business, enjoying your constitutional rights, and suddenly you're in the crosshairs of the law. And it's not just about owning these so-called attack weapons. It's about the very real prospect of becoming a felon for doing what you thought was perfectly legal. Now let's throw in a bit of analysis. These are not folks who are hoarding military-grade arsenals. We're talking about your everyday Americans who happen to own firearms that have become the subject of legal scrutiny. It's like saying your grandma's old shotgun could potentially make her a criminal. It's a twist in the plot that's got people scratching their heads, wondering how common rifles and mags suddenly became the bad guys. The attack weapon ban has created a legal minefield where millions are treading carefully, unsure if what they own could land them in a courtroom facing felony charges. It's a harsh reality that's not lost on those caught in the crossfire of changing regulations and evolving legal landscapes. SC denies emergency injunctions. we've got some recent Supreme Court drama on our hands. The big shots at the highest court in the land recently made a move that's sending shockwaves through the firearm community. Brace yourselves, they denied emergency injunctions on the statewide rifle mag ban. Let's unpack this legal roller coaster. First up, we've got cases with names that sound like characters from a legal thriller. Kinby Pritzker and Nager versus Neal. These aren't just random names, they're at the center of the storm, representing the desperate attempts to put the brakes on a statewide rifle mag ban. So what's the deal with these emergency injunctions? Well, imagine you're racing against time, trying to prevent a new law from kicking in. That's the emergency injunction game. In the Kinby Pritzker and Nager versus Neal cases, folks were basically begging the Supreme Court to hit the pause button on the rifle mag ban.
So I thought that was very interesting that now we have an unelected swamp creature, a bureaucrat, who thinks that they can now make felons.
There are many areas, as you might imagine, especially when you're dealing with firearms, where we just don't know.
Law-abiding citizens, felons.
Is it pretty fair to say that this guy should not have been out on the streets?
Special order. Thank you so much for highlighting what's going on here.
The ATF, before they abolish our Second Amendment rights, alcohol, tobacco, and firearms.
This is going to be a $1.9 billion hit to the firearms industry.
But DC bureaucrats have used this agency to infringe on the rights of the American people.
Is to make sure that our parole laws and our attitude toward violent criminals.
Until they could sort out the legal mess. But spoiler alert, the courtroom said, nah, not happening. They slammed the door on those emergency injunctions like a bouncer at an exclusive club. The result? No temporary halt on the statewide rifle mag ban. It's like being told you can't hit the brakes on a speeding train heading straight towards a legal cliff. Now let's talk about the Supreme Court's decision. It's not just a simple thumbs up or thumbs down, it's a significant move that's got legal buffs scratching their heads. Denying these emergency injunctions sends a clear message. The Supreme Court isn't jumping into the fray just yet. It's almost like the court is saying, hold your horses, let the lower courts do their thing. They're playing the long game, waiting for the legal dust to settle before making any grand entrances. It's a bit like a strategic chess move, and the folks caught up in these cases are left wondering what's next in this legal chessboard. The denial of emergency injunctions doesn't just impact Kinby Pritzker and Nager versus Neal, it sets a precedent. It's a signal that the Supreme Court isn't swooping in with a quick fix. Instead, they're letting the legal battles play out in the lower courts, like a heavyweight bout where the undercard fights set the stage for the main event. Kinby Pritzker and Nager versus Neal. Alright, let's break down the Kinby Pritzker and Nager versus Neal cases, two legal dramas that are putting the spotlight on the attack weapon ban. Get ready for a crash course in legal showdowns. Kinby Pritzker case. In the red corner, we've got the Kinby Pritzker case, a heavyweight in the fight against the attack weapon ban. Picture this as the story of an everyday gun owner. Mr. Kinby Pritzker, who finds himself in the crosshairs of the law due to Illinois' ban on so-called attack weapons. The gist of it? Mr. Pritzker, along with other plaintiffs, took their grievances to court, challenging the constitutionality of the statewide rifle mag ban. They weren't just waving the Second Amendment flag. They were arguing that the ban infringed upon their rights and left them facing potential felony charges. Legal fireworks were set off as they sought emergency injunctions, a legal Hail Mary to hit pause on the rifle mag ban. But, and it's a big but, the Supreme Court recently denied their request, leaving Mr. Pritzker and his fellow plaintiffs in the legal trenches, gearing up for a full-blown legal battle in the lower courts. Nager versus Neal case. Now let's switch to the blue corner, the Nager versus Neal case. Here we've got another set of plaintiffs challenging the attack weapon ban in Illinois. The Nager case echoes the concerns raised in Kinby Pritzker, but with its own unique twists and turns.
There's a hearing that you can't be at, your counsel can't be present, you haven't been charged with the crime.
Makes it less likely for people to shoot things they are not aiming at.
Okay, and he was released based on what charge? He was facing a charge and released?
And you can fire your Congress critter, but you cannot fire these unelected bureaucrats.
Absolutely not. He was very clearly a danger to.
And said he supports a ban on the sale of assault weapons, which there's no such thing.
That's why I am proud to join these efforts to protect gun owners across this great United States of America.
This is just a backroom attempt, a backdoor attempt to get.
So when you look at what America is facing, would you agree with me the best thing we could do as a nation?
Similarly, the plaintiffs in Nagar sought emergency intervention, hoping the Supreme Court would pump the brakes on the statewide rifle mag ban. Unfortunately, lightning didn't strike twice. The Supreme Court denied their request as well. It's like a double whammy for those hoping for a quick legal reprieve. In both cases, the legal arguments are like a chess match with high stakes. The common thread is the challenge against the constitutionality of Illinois' attack weapon ban, focusing on alleged violations of the Second Amendment rights of gun owners. The plaintiffs argue that the ban is a blatant overreach, unfairly turning law-abiding citizens into potential felons overnight. They're not just swinging the gavel at the attack weapon ban, they're questioning its legitimacy and the impact it has on the rights of millions of gun owners. At the heart of these cases is the tension between individual gun rights and the state's authority to regulate firearms. The legal battleground is set, and these cases are poised to shape the narrative around attack weapon bans, not only in Illinois, but potentially nationwide. Illinois Supreme Court's role. The Illinois State Supreme Court is front and center in the ongoing attack weapon ban cases, playing a pivotal role in shaping the legal landscape surrounding firearm regulations in the state. As the highest court in Illinois, it holds the authority to interpret and decide on the constitutionality of the attack weapon bans, making it a key player in the legal showdown. In this legal drama, the state court has been busy reviewing decisions and reversals stemming from lower courts. It's akin to the court being the ultimate referee in a complex match between gun owners and advocates on one side and the state's attack weapon ban on the other. The decisions made by the Illinois State Supreme Court carry significant weight, influencing the fate of these bans and determining their alignment with constitutional rights. The courtroom action is akin to a legal chess match, with each decision and reversal having profound implications for the individuals caught in the crossfire. The state court's involvement adds layers of complexity to the attack weapon ban challenges, as it navigates through legal arguments and constitutional considerations to reach its verdicts. In essence, the Illinois State Supreme Court stands as a central figure in the ongoing legal battles, holding the power to uphold or strike down the attack weapon bans.
They don't care about that fundamental liberty law-abiding citizens in this country enjoy.
I think worse than that, sir. You will see millions of otherwise law-abiding citizens.
And talk about how absolutely insane, ridiculous, and unconstitutional.
How many times was this gentleman involved with shooting at people?
Tearing apart families and making our streets less safe.
And it's time to, once and for all, let those swamp creatures know.
Yes, sir, I believe so.
Okay.
When you research how many pistol braces the ATF expects to be registered, the number varies.
This new rule is.
The first time he was facing at least one felony domestic violence charge. And
as decisions unfold, the court's role in shaping the trajectory of firearm regulations in the state becomes increasingly evident, leaving gun owners, advocates, and opponents eagerly awaiting the outcomes that will reverberate far beyond the courtroom. Denial of emergency stay. In the legal arena surrounding the attack weapon ban, Judge McGlynn takes the spotlight with a recent decision that has left many on the edge of their seats. Let's dive into the nitty-gritty of Judge McGlynn's ruling on the FFL versus Pritzker case, where emergency stays and Fourth Amendment challenges took center stage. Imagine the courtroom as a battlefield, and in this particular case, Judge McGlynn played the role of the gatekeeper. Gun owners and advocates, including those involved in the FFL versus Pritzker case, sought an emergency stay. It's like hitting the legal brakes, asking the judge to temporarily halt the proceedings to prevent immediate implementation of the statewide rifle mag ban. But, and it's a significant but, Judge McGlynn dropped the gavel with a resounding denial. He essentially said, "Sorry folks, emergency stay denied." This decision meant that the legal wheels kept turning, and the attack weapon ban continued its march forward without any immediate interruptions. It was a blow for those hoping for a legal breather. Now let's shift our focus to another layer of this legal saga, the Fourth Amendment challenges. In the same order where the emergency stay was denied, Judge McGlynn addressed challenges related to the Fourth Amendment. This constitutional amendment protects against unreasonable searches and seizures, and in this context, it became a battleground for legal arguments. In his analysis, Judge McGlynn dismissed the Fourth Amendment challenges brought forth in the FFL versus Pritzker case. It's like he said, nope, these challenges don't hold water. The dismissal meant that the court wasn't buying into the argument that the attack weapon ban, particularly its implementation and enforcement, violated the Fourth Amendment rights of the plaintiffs. Judge McGlynn's decision to dismiss these challenges is a crucial piece of the puzzle. It sets the tone for how the court views the constitutional implications of the attack weapon ban, shaping the narrative of the legal battles ahead.
Is changed so that they are not out hurting people, they stay in jail?
There's probably going to be many more boating accidents this spring and summer than we've ever encountered.
This is why we have to pass the REINS Act, because the REINS Act,
As our criminal justice system has gotten softer, that problem's only gotten bigger.
shall not be infringed.
Unfortunately, this is the only magazine that came with the gun, and it wasn't long after I had it.
so we need to pass the REINS Act. We need to absolutely stop this regulation in its tracks.
Take all of the guns from all of the people. That's their goal.
And call on young people to continue leading efforts to end gun violence.
There is no other right where we require individuals to show a need in order to be able to exercise that right.
In essence, Judge McGlynn's recent rulings in the FFL versus Pritzker case have significant implications for the ongoing attack weapon ban challenges. The denial of the emergency stay and the dismissal of Fourth Amendment challenges send clear signals about the court's stance, leaving both gun owners and advocates strategizing their next moves in this complex legal chess game. Expedited review in lower courts. In the midst of the Supreme Court's reluctance to jump into the fray, Judge McGlynn emerges as a key player, making waves with a commitment to expedited reviews in the lower courts. Let's unravel the implications of this decision and how it shapes the ongoing legal saga surrounding attack weapon bans. Picture the legal battleground, and Judge McGlynn is the general calling the shots. Faced with a Supreme Court that's hesitant to take the lead, he steps up, announcing a commitment to expedited reviews. It's like he's saying, we're not dragging our feet here, let's get this show on the road. What does expedited review mean? It's a fast-track process, a swift journey through the legal maze. Judge McGlynn is essentially hitting the accelerator, aiming to reach actual merit decisions in record time. This move is crucial, considering the urgency and significance of the attack weapon ban challenges. Now, let's unpack the decision to move towards actual merit decisions. It's a bit like going from a teaser trailer to the main feature. We're getting into the meat of the legal drama. Instead of lingering on preliminary matters, Judge McGlynn is pushing for decisions based on the merits of the cases. What does this mean for the parties involved? It means no more legal tap dancing. It's time for a serious examination of the constitutional and legal arguments. Judge McGlynn is signaling that he won't be swayed by temporary halts or preliminary skirmishes. He's steering these cases toward a point where the court will make substantive decisions on their merit. The implications are vast. Gun owners, advocates, and opponents alike are now facing a faster-paced legal environment. The decisions made will not be superficial. They will be rooted in a thorough evaluation of the constitutional and legal aspects of the attack weapon bans. It's a shift from procedural maneuvers to a focus on the heart of the matter.
Both specific individuals and the public at large.
Mr. Manguel,
That the Second Amendment shall not be infringed.
let's see what is the most compelling thing to learn from that case.
And stand against this abuse of power on their behalf.
Accept and tolerate.
Well, if your proposition is true,
There's a hearing that you can't be at, your counsel can't be present, you haven't been charged with the crime.
As their duly elected representatives, we must fight back. We must stand tall. We must be tough.
America would be responding in a certain way.
In essence, Judge McGlynn's commitment to expedited reviews and the move towards actual merit decisions injects a sense of urgency and gravity into the attack weapon ban challenges. As the legal battles unfold in the lower courts, the decisions reached will shape the narrative, setting the stage for potential appeals and influencing the broader discourse on firearm regulations. The courtroom drama continues, and the spotlight remains firmly on Judge McGlynn's courtroom as he steers these cases towards their legal destiny. That's all for this video, folks. See you next time.